Now it's good.
And I think to myself, what a wonderful world.
Hello. If you are new here, my name is Chloe and I'm a second year law student. I make videos to do with law, I make videos to do with being a law student. So if you are interested in that, please like, comment and subscribe down below. Today I'm going to teach you how to moot. I have a second round of my university's internal moot coming up. So I wanted to kind of give you my tips, like very basic tips, which will be this portion of the video. Show you how I prepare my moot, which will be like the second portion video, and the third portion of the video, luckily my university are gonna let me actually film my moot. Only my submission, so you'll only hear me, not anyone else, but that will be the last part of the video. I'm going to include timestamps below because I feel like people are at different stages in their mooting ability, so I want you to be able to jump back and forward between this video at any time, or if you just want to be nosy and see if I'm a good mooter, then skip to the end for that bit. So first things first, I'm just gonna talk you through what a moot is. So a moot is where a case has gone to a court. It's usually a civil case and then it gets appealed to a higher court. So there's two appellants. They're the two people bringing the case to the court, the lead appellant and the junior appellant. They will deal with two different points on the appeal. Then you've got the lead respondent and the junior respondent, who are essentially arguing what was found in the first court in the first instance. So every round of moot, you'll rather be appellant or respondent. Leads usually have a broader issue to deal with within the law. For example, I'm a lead appellant this time, and my area of law is duty of care and misrepresentation in contracts. My junior appellant's area of law is contributory negligence, which is a small area of law. So that will usually tell you all you need to know about leads and junior appellants. Leads normally get a longer time. For this round I have 10 minutes and my junior has 7 minutes. Okay, the next thing is terminology. Now, lead appellant, you need to introduce yourself and you need to introduce them, but you need to do it in a way that is suitable. I'm just normally like, may I please call, my name is Miss Moran and I appear on behalf of the appellant. May I present my junior counsel, Miss Chadwick, and my learned friends on behalf of the respondent, Mr. and Mr. Then you need to say, would my lordships, ladyships care for a brief summary of the facts? Quick one here, if you are speaking to them directly, it's my lord, my lady. If you are speaking to them as a group, it's my lordships, my ladyships. Okay, are we down with that? First things first, when you are reading out a case, you need to read out the case name in full. Derry and Peak, I don't know why this came to our head, but it just did. Can my lords and ladyships turn to page X of the trial bundle where the facts of Derry and Peak 1889 reported in the UK House of Lords volume 1 on page whatever are laid out. You need to say the case name and the case citation in full. This is something that will lose you marks. And then they turn to the case that your submission is based on, and you need to say, do you have sight on the case, my lords and ladyships? This is so good to do because you're then getting the judges involved, and there's nothing worse than them flicking through trying to find something and you're already rambling on. They're not going to listen to you, you need to listen to them. Another thing about this should not be scripted. Like, mooting is about thinking on your feet. When you're reading off a script, you're not thinking about what you're saying, you're just reading words. Okay, so our appellants have done theirs. Lead appellant, after your argument, you need to say, unless I can assist my lordships and ladyships any further, I will now pass on to my learned junior, Miss, Mr, whatever, to deal with points 8 and 9 of the submission. Okay, this is going to make a bit more sense when I go through the trial bundle, so don't worry about that. Afterwards, they need to say, unless I can assist my lordships and ladyships any further, I will now hand over to the respondents. The worst thing that I do, and you'll notice because I'm doing it right now, is I love to make a point with my hands, and this is an extreme fall down. I'm still doing it. So when you're making a moot, you shouldn't be using your hands because it's not like a show. You're not putting on a show. You're not putting on a speech. Next, we're going to do skeleton argument try bundle. And you're in luck because I'm actually going to do that now.
So after I got the library, the easiest thing that I do is go somewhere where you can find textbooks and type in the area that your moot's on. So mine was misrepresentation but contributing negligence. Then I control an F, which lets me search the page, type in the specific area of law, so contributing negligence, and then this will take me to the right place in the textbook that talks about it. Redgrave and Heard came up, which is a case that I decided to use. Also, the best thing to do after you've found a case is type it into Westlaw. So get onto Westlaw, read the judgment, see whether you can pull out anything specific that may help with your case. So here, there's another case that I decided to use. Make sure it's got positive or neutral judicial consideration, because that means it still applies today. And if it doesn't use that, then unfortunately it's an out-of-date case. And then just read the judgment and see if there's any particular quotes that the judges said in their judgment which can be used to persuade the court to come round to your thinking. And that's just gonna really give you them extra marks. The facts don't have to be exactly similar to the facts that you've got before you, but you need to apply the case to the facts and say why that supports your argument. And here I'm just having a little read through the judgment, and then afterwards I am gonna download the file as a PDF because it's easier to merge everything together on a PDF, and I'm gonna include it in my trial bundle, so always make sure you download and save. When I start making my trial bundle, the best thing to do is use an old one. So this is the one from the previous round, and then I just use that as like a kind of guide just to remind myself how to set everything out and make sure everything's perfect. So just had a little flick through that and used the computer just to copy it over. So after this, I printed off my whole trial bundle 3 times, which cost me an absolute fortune in printing, but we won't talk about that. And I needed 3, just making sure they all have the right cover pages and make sure nothing has been missed out. There's nothing worse than when your trial bundle has a few pages missing or they're in the wrong way or anything like that. It's just so stressful. So just make sure everything's there, and then afterwards I like to use one of the little machines that my university has to make it into a booklet, just so they're safe and protected, because they are very expensive. At this point, I then went through and highlighted any quote that I was going to use from the case, just so it was easier for the judges to see, and then tabbed them as well. So just put a little tab on with a number so it's easier to refer rather than asking the judges to find a highlighted paragraph. So I sadly had to do my own highlighting and my partner's because she went home and had to do her moot online, which was a bit of a struggle, but it's not really difficult. It's just very grueling work, and this took me absolutely forever to do.
Hello, it is currently 9 o'clock and I have finished the trial bundle, so I'm just quickly going to run through how to make your trial bundle, what to do, and like tabbing system. So this is the cover page. It just like very simply says the 2 parties' names, and then at the bottom it just says Edgehill University internal moot competition and the date. I don't think you need to do that, but I just like to do it because I like to keep these and like look back on all the emotional times. So then if you go to the first page, you've got the same layout as your skeleton argument in the Court of Appeal Civil Division, the appellant respondent, trial bundle for the appellants, because that's what we are. Then in alphabetical order, you need to have your cases, as I mentioned before. So you've got your skeleton argument, which is going to be first. Then you've got your statute. So we've got like the Contributory Negligence Act. This is all in alphabetical order. And then this is why we use tabs, because otherwise you wouldn't need them, but because you go back and forward throughout it, that's why you need it. So then I'll go into the skeleton argument. So in the skeleton argument, you've got, again, in the Court of Appeal Civil Division, between the two parties, appellant respondent, and then skeleton argument of the appellant. And then you've got your introduction. So this is an application on behalf of the appellant to urge or Court of Appeal to overturn the decision in the High Court. Oh my god, yeah, that's right. I was like, yeah, I was getting confused. Then the background, which is just copied exactly from the scenario. So you don't need to worry too much about that. Just make sure that your paragraphs are numbered. And then on this page, we have our legal submissions. Ignore my handwriting, I'm going to talk about that in a minute. So that's what you're arguing broadly. And then you've got, I've used two cases for this because they're both important to say the same thing. So then your case in italics, and then the case citation, and then all of that. The conclusion, in conclusion, the High Court decision should be overturned on the grounds set out above. Then you've got your legal authorities, again, alphabetical order. My name, senior appellant, junior appellant, Edgehill Chambers, 11th of November, because that's when it was made. So I'm just going to quickly run through the tabbing system. So obviously, because everything's in alphabetical order, but you're saying your cases at different times. So obviously I'm going H, P, R, S, S, F. So like, it's different, it's not alphabetical. So if you're the lead appellant, your first case used is going to be tab 1. So you ask them to turn tab 1 in the trial bundle. Here, the facts of Headley, Byrne and Heller are laid out. Now this is my copy, not their copy. So their tabs will all be the same. But I don't know if you can see, I'll just try and show you. I here very briefly write the facts out in bullet points. So obviously I told you not to use script before. You're not going to use script. But on this page you've got the facts lined out just in bullet points, so in case you need something to refer back to, in case you get confused. So then I'll go to tab 2 of the trial bundle, which is where my first quote's lined out. And then I've just got like a little sentence: didn't have an exclusion clause, must have reasonably known valuation could be relied on. And that's just little things to help me. So obviously read out the quote, and I've just got the little points here that I can just refer to if need be, in case I get confused. And I do that throughout the trial bundle because you don't need a script, but these are really like good points that you can use. And obviously like that's everything that I needed to show you. Tomorrow I'm gonna like vlog like what to wear, things like that when I'm getting ready. So I shall see you in the morning. Hey guys, so I just wanted to quickly come on before I have to leave for the mooting competition to just discuss like outfit choices. Like, you should be taking fashion advice from me, but I've just got on this top from In The Style. This jumper's from Primark. This skirt is a work skirt. It did have a label on, but I cut it off because I am broke. And then just black tights, and these little loafers are just from Next. Basically, like, my trick of the trade is, as long as you've got a nice blazer, my blazer's from Next, it's just plain black one, and you've got nice shoes, you can blend everything else, because obviously it's quite expensive, like, buying suits and things. So I just get loads of like worky bits from Primark, and I literally have the one blazer and the one pair of shoes. I'm just gonna leave now for university, and I will see you after the moot. Yeah. My name is Miss Moran, and I appear for the appellant in this matter. I would like to introduce my learned junior, Mr. Chadwick, who appears also for the appellant in this matter, and my learned friends. Unless I can assist my ladyships any further, I will now move on to my first submission. You may.
Hi, Ed and Chloe here. I forgot to ask if they would like a brief summary of the facts, and I also forgot to give them a quick run through of my submissions, so that's a good start.
Yeah. A representation made by one party to another that induces a third party to enter a contract is actionable by the third party, provided that the first party knew or ought to have been aware that the representation would likely be communicated to the third party. Unless I can assist my ladyships further, I will ask you to turn to tab 1 of the trial bundle, where the facts of Headley, Byrne and Heller, 1964, reported in the Law Report Appeal cases on page 465 are laid out. Would you care for a brief summary of the facts, my ladyships?
No, thank you.
Thank you. I will ask my ladyships to now turn to tab 2 of the trial bundle, where Lord Reed's judgment is laid out. A reasonable man, knowing that he was being trusted or that his skill and judgment were being relied on, would, I think, have 3 courses open to him. He could keep silent and decline to give the information or advice sought, or he could give an answer with clear qualification that he accepted no responsibility for it, or he could simply answer without any such qualification. If he chooses to adopt the last course, he must, I think, be held to have accepted some responsibility for his answer being given carefully, or to have accepted a relationship with the inquirer which requires him to exercise such care as circumstances require. On application to the facts, my ladyships, in this case, Slick and Speedy Motors did not have an exclusion clause in their valuation to austerity car procurement. Therefore, it is fair, just and reasonable for Mr Q to have sought to rely on this information when it was passed on by austerity car procurement to himself. Also, Slick and Speedy Motors' valuation should have reasonably known that this might have been relied on. Unless I can assist my ladyships any further, that concludes my submission.
Obviously, that was just a very, very brief example. That was not my whole moot. I just filmed that afterwards. So it was just a really quick example of a submission. But hopefully that gave you some advice and some help.
Okay guys, that was just a very, very quick little introduction into mooting.
Come on, let's get the photo.
That was just a very quick introduction, and I would like to thank all my learned friends for watching.
Please subscribe and like.
Thanks.